a disability carrier have a meaningful dialogue with you before they deny or terminate your disability insurance benefits? The answer is yes, but I want to take you through the standard claim denial letter so you understand what a disability carrier thinks is meaningful dialogue and what one federal judge thinks is meaningful dialogue. Now, one of the most common reasons found in a denial letter is the phrase, "There is no support for an impairment that results in restrictions and limitations and the inability to perform your own or any occupation." Let's talk about the clear as mud denial letters that I normally see. The denial letter is going to review the medical records that the plan or the carrier allegedly reviewed. They're going to cherry pick them. They're going to refer to the disability carrier's selected medical review. Of course, disagrees with your physician's conclusions. They're going to top off the denial letter with the opinion of an in-house vocational specialist. That vocational specialist is going to ignore your doctor's opinions about your restrictions and limitations. Instead, they're going to rely on the disability carrier's liar for hire doctor's opinions. He is going to determine whether or not you can go back to your past occupation or whether you have transferable skills that will allow you to work in another occupation. This denial letter will always invite you to submit additional medical information, including treatment notes, diagnostic test results, physical therapy notes, and prescription medications. The letter will also generally ask for your treatment plan and any information about your specific restrictions and limitations, even though you've already submitted an attending physician statement form that the carrier's rejected. As part of this appeal, the disability carrier may have you examined by a not-so-independent medical evaluator who's nothing more than a hired gun. You might be tempted to bring your records to the IME reviewer if there's an IME. And it's not uncommon for the IME provider to refuse to look at your medical records on the basis that you've been tampering with those records, or you may have removed damaging information. Never mind that the IME has already gotten a biased, cherry-picked summary of your medical records from the disability carrier. Now, don't be surprised that the IME may last a few minutes or the IME doesn't even do a thorough examination. If possible, you want to videotape that IME or have a witness to take notes about what occurred. You can even do a summary of the IME. But better yet, I think you should have a lawyer to represent you before you go to the IME or get your own IME or functional capacity evaluation to determine your restrictions and limitations. You may even want to see your own doctor the day of the IME so that there's a comparison as to what the exam findings were between your doctor and the IME doctor. In an ERISA case, the plan administrator or the carrier has to provide you an opportunity for a full and fair review of the claims denial. So what is that and what happens? If you end up in court, it's a judge who's going to determine whether or not there's been a full and fair review. In an ERISA case, there's two possible standards of review. In other words, a judge can use, depending on the language in your policy or plan, a de novo standard of review. That means that the judge gets to substitute their judgment for that of the disability carrier. Unfortunately, the more common standard of review is arbitrary and capricious. And a judge is required to give deference to that denial, even if they disagree with it, even if the denial is illogical, implausible, or without support. Unfortunately, the arbitrary and capricious standard of review really does limit what a judge can do. But the judge does have the right to consider some factors like whether or not they had you undergo an IME, whether they relied on a paper review of existing medical records, whether they provided their quote unquote independent experts with all of the relevant evidence, and whether they considered a favorable Social Security decision. So that's a lot to take in. Let's see how one judge reviewed a claim denial to determine whether or not there had been a full and fair review. I'm going to talk about the case of Quesada versus Lincoln Life. And Quesada was employed by Gentech as a senior farm material specialist. That was heavy work. He became disabled by intractable back pain and was paid disability benefits from 2015 through early 2020, 5 years of benefits. Lincoln said, "We've had enough. We're going to deny your claim on the basis that there's no support for impairment that results in restrictions and limitations and the inability to perform any occupation." Does that sound familiar? Using the arbitrary and capricious standard of review, the judge found that there had not been a full and fair review for 4 reasons. 1, there was no meaningful dialogue with him because the denial letter didn't tell him exactly what he had to do to perfect his claim and was unacceptably uninformative. I like that. In this case, Lincoln had not been able to contact his treating physicians, and they didn't tell Quesada until after his claim was denied. Now, they didn't like the bare bones medical records that they were provided, but they never told him that the records had too little detail. The standard boilerplate language to submit additional information didn't say, hey, we don't like your records. There's not enough detail. This is what we're looking for. And the judge suggested that Lincoln had a duty to ask for what it needed and to engage him in a meaningful dialogue about why the claim was denied. Number two, there was inadequate consideration of the subjective reports of pain. Now, the denial letter mentions pain a lot of times, but it concluded that the medical records didn't support his pain complaints or impairment. However, Lincoln had acknowledged he had a chronic condition with exacerbations and that his condition was pain-producing. So you can't have it both ways. They ignored his supplemental statement about his pain. And the fact the judge said, look, not only is your position inconsistent, but when I look at the policy or plan, there was no provision that said, hey, you can't use self-reported pain as the basis of disability. Lincoln created a standard of proof that didn't exist in the policy. Number three, there was no evidence of improvement. That's kind of crazy because their position went all over the place. Sometimes there was improvement, sometimes there wasn't improvement, but they had acknowledged that he had a chronic condition with exacerbations and that his conditions were pain-producing. So would you necessarily see evidence of improvement? Doubtful. So why did you tag the denial on the basis that there was no evidence of improvement? The judge was not impressed with this inconsistent, illogical reasoning. Number four, they didn't give any weight to the Social Security decision. Now, the Social Security decision in this case was actually unfavorable. And Lincoln said, look, Social Security denied the claim. They were right. We were right. We were right in relying on this. And the judge said, well, wait a second. There's no law that suggests that a Social Security denial automatically makes an insurance company's parallel denial reasonable, particularly since insurance companies employ different eligibility requirements. What is the difference? In Social Security disability, at step 5, the issue is, can you engage in other work in the mythical, not real world national economy in view of your age, your education, your training, and experience? Most disability carriers will define own occupation as the inability to do the material and substantial duties of any other occupation by virtue of your education and training and experience. You didn't hear the word age, did you? And many times disability carriers will reject a favorable decision on the basis that age is not a factor in the definition of disability. So obviously the reasoning here did not support a claim denial. And the judge said, hey, you didn't get it right. But unfortunately, the judge gave Lincoln a chance to get it right because the decision was remanded. I think we've learned 4 important lessons about what is the basis for meaningful dialogue.